Good morning. This is Pallavi Ahluwalia from Ahluwalia Law Offices. I'm the managing attorney there, and I am glad to be here today with you at this event and hope to be able to reach out to our community, especially the immigrant community, so that I can go over what's happening right now in our world. And everyone that has followed immigration for a while kind of know that things are fast and furious at this point and a lot going on. So, Ahluwalia Law Offices, or as I call it, my team ALO, has been around in the Dallas Fort Worth area, also on the East Coast, for the last about 18 years. And we've been very happy to represent people from all corners, but the mainstay of our practice, besides family law and corporate law, has become immigration, and that's what I think I associate myself most with. So, from a perspective of a lawyer, and who's obviously in the sphere of interpreting immigration law, analyzing memorandum, uh, proclamations and orders from the president has become more routine as opposed to decisions that have had precedence. So, as in, rather than reading court cases, we're actually just reading what memos are published here or what proclamations have come in from the government. And unfortunately, for the last several years, we've been sitting ducks who have been riding the waves of populism and politics. And also, I mean, who had really thought about immigration law as being so politically opinion driven? So it was a very little attended to area of the law. It was the background of what made America hum. It was the reason why America was humming because we had immigrants coming in and giving their best. They had left their other countries. They kind of knew that our countries, wherever we came from, weren't giving us our best shot, and we were the brain that and had the verve to come here and do whatever we could the best. So. And I've studied the waves and history of waves of people that had kind of put the American experiment afoot and made it a roaring success. So, but these announcements that have come in recently have been a little bit more disturbing because they are riding the populism wave, which means that they are a little bit more exclusive and they are more protective of the US workers and US people who live here. So I'm just going to briefly kind of go over what's afoot right now, what changes are afoot. The first thing that I would point to would be on the employment immigration side. So we've had a lot of action that started out with the COVID and a lot of consulates that got kind of locked down, basically got impacted, and people couldn't enter the country. The and those are just visa routine services. So if you were actually an immigrant who had stepped out, or non-immigrant who had stepped out of the country for stamping, you got stuck there. And I do represent a lot of people who are in a position to mind. They had emergencies that got them in to India. They had visits that got them to India. They had other issues going on, and they just got stranded. But right after what was going on, of course, with the consulates also came the proclamations. We had the proclamation 10014, and then we had 10052. Now, most of you all are aware of that. But if I were to just briefly summarize these proclamations stopped the entry of people. So all family based immigrants who were on the family preference side of the visa bulletin were not allowed to come in. So we're talking about the F1, the F2, the F2B, the F3, the F4 siblings, children of citizens, spouses of green card holders, children above 21 of green card holders. F1 are unmarried children of US citizens. So all of these got impacted. And of course, then were also all the other visa categories. So J1s, H1Bs, L1s, H2B. So anybody that was abroad at this point, the the proclamation kind of applied to you and you were not welcome back in the country. A narrow exception was the healthcare workers, and those were allowed in the country. So just a little bit and I kind of have a little bit of my memory triggers here. Now, before I kind of move on to what's afoot inside the country, and we're talking about the H1B program, that's again a major change that has happened. We've had the national interest exception to the presidential proclamations that have been set up. If you can go through them, they're on travel.state.gov. You could just kind of understand what they are. But even above that, there has been a lawsuit, and this is a lawsuit that is National Association of Manufacturers versus the Department of Homeland Security, which has enjoined the government from enforcing the Section 2 of the Proclamation 10052 against plaintiffs and members of plaintiff organizations. So, what I'm wanting to let you know is that if your company or somebody that you know, or your employee, or whoever it is, if you have joined the US Chamber of Commerce or the National Retail Federation, TechNet, or Intrax seems to be a company, of course. But if you are part of the National Association of Manufacturers, again, the US Chamber of Commerce, the National Retail Federation, you are going to be allowed into the country without being subject to the entry restrictions marked in 10052. So these are things. So we've had some people just in this past week who asked us, and we were actually helping them with the national interest exceptions statements. And what we were having our client companies join the Chamber of Commerce, the US Chamber of Commerce, and see if the government would bite and allow these people to go in without being subject to that. So that's one thing that is ongoing right now. Now, the major change is and I'm talking still about employment based immigration. The changes are to the H-1B program and the green card program, and that is by the Department of Labor and the DHS together making a regulatory change as to how the wage levels would be figured out. So this was pretty much almost overnight. On 6th of October, there was this announcement, and this big bombastic announcement said that the new Department of Homeland Security and Department of Labor rule restores the integrity of the H-1B visa program, and it laid out different things. A lot of those things are going to come into place, and I'm going to go over those from the 8th of December. But what came into being from the 8th of October is the wage data. So now the OES wage data is doubled, or actually more than doubled. So earlier wages were decided by the 17th, the 34th, the 50th, and the 67th percentile in the four wages, and right now it's escalated to 45th, 62nd, 78th, and 95th. So basically, uh, the salaries starting out for an H-1B worker is going to be what is being paid at the 45th percentile level to US workers in similar positions or in the same position. And if you're level 2, which is what everyone wanted to be recently, then you're at the 62nd level. So, which is again a huge thing, because we're talking about numbers that are going from as benign as 78,000 to right now being 105,000 for the same position. So we're talking about some level ones that are getting majorly impacted. And I don't know of anyone who's, I hope they do one day, but that are paying their H-1B workers about $300,000-400,000 at the fourth level of salary, and that's what's being mandated. So the government's understanding of merit is very similar to how this current administration reads merit. So if you're meritorious, then you should be paid the highest. So if you're not smart, it doesn't mean that if you're a student that you've come out and you obviously nobody without experience is giving you this job. They're thinking that if you are that smart, then you should be making 45th percentile of the salary. It's a shame what they've done to the system, but we have ways to get around this. So of course, it's by this action, the government has made the hiring of the H-1B workers a little bit harder, but there is a way to now research and pay for private wage surveys, and that's the way to file the labor condition applications, or even do the prevailing wages related to perm, right, which is where the green cards are going to get accepted. So this is of course going to increase for a lot. If you I have any employers who are tapping into this is going to increase your costs, because now you have to obtain a survey before you file for your employee. But just remember that this is better than having to pay the employee maybe $30,000 more in salaries over the year. So if you're paying $500-600, it's a cost that you may have to take into consideration to just watch this. So now everyone remembers the last 3 years has been about contracts. It's been about trying to line up the positions from your work location down to your employer, leading through the several layers. And if you were laid out, then there were other issues and RFEs. Well, lo and behold, now is a requirement again reinstated, which had been actually waived off after the IT Serve Alliance lawsuit that was won by plaintiffs, in which the government was forbidden to ask for these things on a discretionary basis. So they said, let's just fix this once for all. Let's just go ahead and make this as the rule. So it's not going to be something that we see as memos that we suggest this, or we want this, or we'll evaluate this. So they've now made this harder. So the interim rule now that is published is actually now waiting its 60 days from 8th of October, so about the 8th of December. The interim rule differentiates between worksite and third party worksite. And the worksite obviously is going to be the physical location where the work is performed. And third party worksite, we all know consulting companies and that we work for, that the third party worksite is your end client location. So it requires that that the case that is filed establish that contact completely. It also requires that for the third party placement, the validity of the H1B would be only in 1 year increments, and it reimposes what I was just discussing, the contract work orders or itineraries as a requirement to be able to kind of go with this. So basically, in one shot, it's kind of impacting hugely the consulting services businesses, as well as the ability of the beneficiaries or the employees to go through consulting companies as their primary employers. So it's basically either telling you to go directly work for end clients and kind of not deal with what's happening here. So it's a little bit unfortunate right now, but that's what's happening. So they're also saying this one odd thing that I kind of thought, that the company that is sponsoring you has to show whatever that you're about to do is related to you as a beneficiary, is related to the end product, which is directly linked to your H1B employer's business. So obviously I think we as attorneys can probably argue that if it's this employee is being hired as a software consultant, then it's a consulting business. So now titles would change. I would suggest not going in for engineering titles, because consulting companies are not doing hardcore engineering, but they're definitely consulting. So let's see how that comes along. Now, this is all going to be, unfortunately, a bit of a trial and error with this government to see how it works. Now, we're hopeful that this is something that would either get enjoined or be overridden, hopefully by the next government. We don't know what that's going to bring about. So that about the H1B category and the recent changes, COVID related, the proclamations. I would like to move on to the family based immigration. So there are changes, obviously, that I discussed upfront that impacted a lot of entry of people that were family based immigrants, right? So if you were a green card holder waiting for your spouse to sponsor you and bring you back in the country, you were one of the impacted categories. You're a you were married, children of a US citizen, and you were about to get done. Well, guess what? You got impacted too. The good part was that anybody that was in the country, however, was continuing to file their adjustments of status, and there were record filings of adjustments of status because the family based visa categories remained current for a while. And so now we have the only exception that existed during these times have been the immediate relatives for all of the rest of the year, which is December 31st. They are so the family based preference categories still are if abroad cannot enter the country. So this is also to briefly let you know it doesn't impact Indians as much, but diversity visas have been impacted because those are given till the 30th of September, and after that they kind of go back into the pool. So even if the people that got lucky, and I'm talking about people from Nepal who qualify for them and a few other countries, Sri Lanka in the South Asian continent, they all were actually impacted by not being allowed to come into the country, and those numbers getting reverted back into the pool, and they'll have to apply for their DV lottery again. The government has shortened the number of refugees that can enter the country, so there's an impact right there. Now, refugee entry into the country, and this just briefly touching on this, is dictated by an annual number that is decided by the president on an ongoing basis. So, just to kind of tell you how state of affairs are, so you, if you're non-immigrants or immigrants from India mainly, you'll kind of understand. And refugees are not somebody, not the most used categories for us, that you know how they're impacted. So, on an average, 95,000 refugees enter from all over the world that US allows, and this is by conventions that have been signed by US and have US has actually been a leader in doing the right thing. And these are people who are displaced because of famines or wars, and they're the refugees that come here. So from 95,000 last year, the number was escalated down to 18,000. And this year, I think it's about 10 of 12,000 that the government is allowing. So from 95,000 to about 10,000, that's pretty poor on part of the US. And this is where we are leaders of doing the right thing. Also, I would like to kind of mention that recently, and I think if I were to kind of make a judgment about what kind of calls that I've taken over the last several months, maybe weeks for sure, and I would say months for this particular, status that I'm talking about. This is the visitor visa in the country. So we have had a lot of people who are visiting the US as they come every year. They come in, visit their relatives, maybe kids, siblings, whoever it is, and then they leave the country. A lot of them were forced to file their first extensions, and then now they're coming up on their second extensions. And I've been asked this question repeatedly, and I'm going to bring it out here again. So if you have a choice to have the relative return safely back home, I would advise that that be the case as opposed to filing a second extension. What's happening, and I've noticed this from other people who have come to me and showed me, what's happened, that the government, even if they're making their decisions because they're late and they're running behind on everything, as we all know, they have started to kind of go and give shortened I-94s. They've mixed up on the fingerprinting notices. They're doing one fingerprinting notice. They're making assessments. A lot of people that filed themselves did not ask for the full 6 months. They asked for 4 months here, 2 months there. The government is consolidating it, disregarding one request, not paying attention to another. It is a complete mess. So if it is possible for you all to have your relative leave rather than deal with a shortened I-94 and then leaving in an urgency, I would say you should do that. Now, if you are forced, and of course your relative may be in a situation of health where they can't leave, or they are in the high risk category as we understand it, then you have to make sure that you do a solid filing. Let the government know that there is another pending case. Make sure that the entire case is enclosed with your filing. A lot of people that file themselves don't actually take a copy of what they filed, so we don't even know sometimes what they filed. But those are important things to enclose in your application, plus showing that the relative will leave the country. It's still a short stay, it's only COVID related, and that there are emotional ties back in the home country from where they come, and they also have some financial strength in their home countries. So these are important things to hit up on, and I would like for, if you are going to engage in a second extension, I would ask you to be careful about that and just make sure that you're putting this in with caution if you're not being able to send them back right now. So the other issues on the immigration side that we're seeing are delays. So I think that's my the second most asked question is, I've been waiting for an EAD, I've been waiting for this, and I'm waiting for that, and I don't know when it's going to come through. What do I do? Well, earlier I would say you just have to wait. Recently, premium processing services have been introduced. The government will be charging up to $2,500 for processing or escalating your cases, which is not such a bad thing, because if you're really stuck, then that's at least an option that you have to get out of it. Plus, the government makes money, and we all know that they're struggling because they've kind of sat around cases because of the anti-immigrant sentiment that they were passed down from the bosses down to them. And now when they're kind of looking at all these cases, there's a huge amount for them to process. So the premium processing will actually just fix that a bit for a lot of people. And my third most asked question recently is my downgrade question, and that comes to the employment-based immigration. Can I downgrade or not? Am I qualified? I want to downgrade is the question, and I just want to do it. And should I wait for my EB2 category to be current? We kind of understand that EB3 got some good luck this November, the October visa bulletin, and November we're still waiting for, so we don't know. And again, you can see it's the 19th, and there's no sight of the visa bulletin. So something tells me this is going to run as long as it did last time, and we're not going to hear from the government till the end of October. So just be prepared, whatever you're planning on doing. Now, on the downgrade request, what my thought here is, if your perm was written with at least 2 years of experience or a 4-year bachelor's degree, then you're qualified for an EB3. I don't agree with people who are just using just a master's with no experience, because that's our understanding is that does produce noise. Now, some people have been able to argue the master's degree as a 2-year skilled worker, and by all chance, that's something you have to try. But if it is something that is making you spend a lot of your money on the 485s, which you're kind of putting on top of the I-140 that is not confirmed yet. So that makes it a lot of risk that you're taking with what you're doing. So in all cases, just be aware that it's a little bit more tough in its adjudication right now, the government. There is a public charge rule in place, and I know people have done their research and they understand it. You have to make sure that all four prongs related to public charge are clearly elucidated and you have evidence. Now, if you're enclosing your bank statements, 12 months is required. So it's something that you have to just be aware of. And if it is, I have a lot of people that I end up kind of advising and cautioning them about this, is that if you worked for your employer in the past, and you want to come back to that same employer and you want to do something, have them file a 485J, the employer has to confirm that they have to declare to the government since when you've been working. And when they say you're not working there, that may be something that is out there that can impact you negatively. So be aware. These may be theoretically future offers, but they're not reliable. So your bona fide intent has to be declared with how you're running your case. So how you're showing the relationship between you and your employer. Your intent is of utmost importance. So your intent should not be, I'm here, I'm going to file my green card, I'm going to scoot up out of here in 180 days. Don't do that, because there was an introduction of or a reminder to us in July, 15th of July this year by the government, that said nobody has a right to a green card. Even if you meet all the categories, we will still hold a set of discretionary factors in our hands to be able to decide whether we give you the green card or not, which means that you have to look at it as a most conservative interpretation of bona fides. So do your best, guys, and just make sure that whenever you're filing, you are just putting out the best case out there. Of course, Ahluwalia Law Offices or Team ALO is always here to advise you, to help you, to take your matters on. We've been around here, and we're happy to be around our community and to be able to provide our opinions and take on their cases. But when we as attorneys push you and ask you for more documents, it's because we are not paper pushers. We're not just taking your documents and sending them out to the government. We are analyzing the law and the trends and what's out there, and then we're processing your matter. Then we're making arguments, because every exhibit that we add, my team will add dividers that argue to the government as to why we have that document in there. And that's the importance of what immigration law is. It's not about just form filling, it's really not. So we hope that this information has been useful in in our field of immigration right now. And thank you so much for hosting me. And a shout out to the Near Me team, Anu Jacob. Thank you so much. And I look forward to coming and speaking to you all again.